today is the day. This is supposed to be a media request hearing. Judge Danelle B. Lusky will be hearing it. And then at 9:30 will be Lane Myers hearing for his motion for recusal of Judge Metcalf. I don't even know if this hearing here is actually going to be streamed. It may or may not. I just wanted to try to catch it just in case it was. But also it's just good to get a head start and get the stream going. Make sure there's no technical difficulties before the actual hearing. So, make sure everything's working before we get to the real good stuff. Dad in the chat, can you hear me? Is the audio good? I actually turned off all my fucking fans and air conditioners for this, so the audio would be better. Welcome into the chat, Dad. Thanks for being here. Let's see. I think that the next hearing is going to be quite an interesting one, even if it's not a positive outcome for Lane. It's just definitely going to be interesting to listen to. Nice. Thank you, Dad, for letting me know. During the hearings, I try to just shut my mic off and not interrupt because I don't want to, talk over any important information. And you never know when there might be important information. So when it comes time for the hearing, I'll be very quiet, and then we might talk about it after. It's kind of ironic how this is a hearing for media request, which the court is supposed to live stream, but Oh, here we go.
So I'm going to call the cases. Rachel Stiles for the state, and Your Honor, the victim is present.
Thank you. And Mr. Resnick, you're here as advisory counsel, correct, sir?
Yes, Your Honor. Mr. Myers is appearing as his own attorney.
Thank you. And Mr. Myers is also present. I just want to place on the record, I came into the court early just to get my paperwork in. Mr. Myers also came in a little bit early. We had a little bit of a conversation. It was on whether or not this was going to be live streamed, on whether or not the media hearing was set first, and whether that would be live streamed. I think that about sums up our conversation. Is that fair, Mr. Myers? Just make sure
I asked you if I could charge you with harassment for putting me on YouTube, and
I forgot about that. And I indicated this was not on YouTube, but live stream. Additionally, because I wanted to make sure Mr. Myers had received it, we gave him a copy of the shortened transcript that the court requested because of statements Mr. Myers had made in his motion. And I wanted to make sure he had an opportunity to read that, which he did. But before we begin with that hearing, I have two motions for Mr. Brown. Thank you. And one for Mr. Kelly. Is Mr. Kelly present? Thank you. I see you both here. And I believe you both are requesting the same thing to both audio and video record. And I believe there were some other gentlemen requesting to audio record as well. First, I wanted to check the state or the victim. I'm inclined to let the audio recording go, even though we are live streaming, but I have some concerns with video recording that I can place on the record. I'll hear from the state first, or if the victim wishes to speak, I can hear from the victim as well.
Want to be heard? Your Honor, I don't have an issue with the audio recording. I do have an issue with the video recording just because it's harder to control and make sure that things aren't being recorded that aren't supposed to be being recorded, including the victim, screens, court personnel. So I would have concerns with that. The only concern I would have with the audio recording is if we have had issues in prior hearings where people will try to put their phone where it could still film even though they've been ordered not to film. So that would be my concern about cell phones in particular because of the fact they have both capabilities.
I'll let you talk with Mr. Resnick first, sir, if you want.
Oh, yeah.
Before you make, I was going to ask for your position as well, but I'll let you talk with Mr. Resnick if you want.
I was going to talk about something.
Okay, that's fine.
It's my turn to say about the.
About audio and video. I have no problem with the audio. I have some concerns with the video, and as does the state, but what any position you have with regard to audio or video recording in addition to the live streaming.
I support it. It's in the rules. The 122H is in the rules, right? And so my position is that we've kind of went over this with your whole admin order thing that we went through and all that, that it's been told to us that as long as we follow 122H, it won't be a problem. As far as video, there's already rules in 122 that state who you can and can't film and all that. So to put a blanket restriction on everybody instead of holding each person accountable, like if there's rules and a certain person doesn't follow them, that person should be punished. It shouldn't lead to a blanket ban for all people who are willing to follow the rules, but they're punished because somebody else didn't follow the rules. And that's sort of what happened. That's kind of why we're here for the change of judge too, is because before anybody even violated the rules, the state argued that the victim would be harmed, but the rules of the recording say that you can't film the victim. So if somebody were to film the victim, they should be punished individually versus a blanket ban on all media. And further, the defendant's rights outweigh the victim's rights every time. Anytime there's an intersection of the victim's rights and the defendant's rights always prevail. So the defendant has a right to a public trial, and the press and the victim can have you can weigh out the differences of the press's rights and the victim's rights, but the defendant always has a right to a public trial. And under Rule 9, the .2 or 3.3, media can't be excluded, but somehow the other judge was excluding them from even coming in the building. And so it shouldn't be a situation where the media has to decide. I can sit home, listen to the audio, and make a recording of it, or I can come to court and not be able to record anything. So it eliminates the possibility that they come to court and record. So you're forcing them to decide, okay, do I give up my right to go down here and be in the public courtroom because I'm being forced to sit home and record it so I can, review it later? Or I believe as long as nobody's violating the rules, but it's like a prior restraint on the media.
Thank you, Mr. Ryan. Having considered all the positions like I believe it is live streamed and additional information allegations of serious
This is my hearing. I need to be heard to get my. A request for 122 is my hearing. I'm the moving party, Your Honor. Your Honor, I was prepared for an objection, and I brought a motion in here that I'd like to file for 122. And I also prepared to be from here?
Yes.
I am the moving party in this request. are we gonna need to do? Good morning, Ms. Stiles. Good morning, Your Honor. Good morning, Mr. Myers. Good morning, Mr. Resnick. Comes now Mark William Kelly appearing on behalf of the Reluctant Prophet YouTube channel, RPV Media, and the American public, hereby submits a motion to affirm his First Amendment right to report public proceedings and manner opposed to the description of said elements of Rule 1, of which the Supreme Court ruled that which courts may limit use of recorded voices, thus request that and cannot hold the constitutional not only those who seek whose why a constitutional right should be overridden unless they meet that burden. This country must be now. Before Judge Metcalf, Miss Rachel Stiles of Pima County stated in open court that they are now management of the implication was unmistakable. I will be watching the government from engaging in constitutionally protected activity. The statement made by a government official raises serious and rights. The course of the Supreme Court that viewpoint discrimination as viewpoint discrimination in as well as the court also
So are you not considering 122D2B, where it specifically states order video coverage effectively obscure the face and identity of a party, victim, witness? Sorry.
Your Honor?
It's just a
I know, and I'm not prepared to answer that. I object to being compelled, suggested, or pressured into using the term victim in reference to Ms. Shannon Walker. As far as which I learned in summer school government class, a person is innocent until proven guilty. Referring to Ms. Walker as a victim before a jury verdict risks undermining Mr. Myers' presumption of innocence.
and I give you 3 minutes, sir. I give you extra time, and I'm letting you know what it is. You have 20 seconds. Go.
I'd like to respectfully ask this court to enter in Exhibit A, Shannon Walker's public U of A website, and Exhibit B, Shannon Walker's oath of office, confirming she has an oath, has taken an oath of the Constitution, as well as everybody else in the Constitution that is subjected. The only people in this courtroom that are not objecting to this are people who haven't taken an oath of the Constitution. I think that's a sad state of affairs we're in.
Thank you, sir. Specifically, under 122D1H, the court can take into any other factor affecting administration of justice. I believe that the way this case has arisen, the stress that it has put upon the victim in this matter, which is a term of art used in a legal case, regardless of whether or not somebody has been found guilty or not, the victim is one listed in an indictment. So based upon that, the administration of justice, and to assure a fair trial for Mr. Myers as well as the victim in this matter, I find that videotaping is not helpful to this case and in fact could impede justice for both the defendant and the victim. So I am denying the videotaping. Yes, sir.
You're denying before I have a chance to talk to you.
Wait a minute. I want on the record if I could submit exhibits on the record.
Sir, no, sir.
On the record findings of true that could come across.
Sir,
Yes.
I,
No, I'm Mr. President. Yeah, I put in a request, and my biggest problem is you're denying our request before I even get to talk to you.
go ahead, sir. I'm
Under, I'd like to point out quick here, he covered a few of the things I want to say, so I'm not going to go over them, but I'm like to pass these on.
Sir, what are they?
This is what
I understand, sir. I'm sorry I got it confused. I appreciate that you feel that way. Yes, I did. Yes, sir. Go ahead.
I can have 3 minutes.
Yes.
Anyway, so 122H, what 122H, we don't need to measure this but in advance. And for you to say you get to 122H, that's
I didn't, sir. I said I wanted to have a hearing to make sure that I didn't have any issues or confusion with that.
so.
And
Can I read 122H?
sir, and I'm excuse me, the audio taking. So I don't.
You don't have to allow it because all I have to do is, you know, I wasn't. I have been Joseph, so I can't record my Metcalf. Saying, I just and that means I can hear and notify and then turn on my phone for it. I don't and this is the main problem. I might get you a copy of this. And
Can you tell me what it is, sir?
yeah, this is Supreme Court codes that are blown up by your security staff. The ones you request, they blow all this up. So I'll give you guys each a copy. I'll take one. If you give them all a copy to the judge,
Sure.
I'll blame mine. He already knows this pretty good, but the court and the staff. And the other thing I would like to do is the petition to amend 128H. So everyone here, Matthew Walker is the one sitting right here that is trying to amend 128H. So they know we can do it now. They're trying to stop us from doing that. They're trying to amend 128H, so I can't do this. All the people that's doing this complaint are here. The ones that the rules are here. Here, they win this petition, then but they I think it's just if you do that, like you said, here, the defense, defense, defense attorney, I should be and not I can see no people not but the witnesses they would choose, you know, this 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 I mean, that administrative work is causing the change. And right on it says that you have to follow 122. You can't make any rules that's not inconsistent with 122. And you made 46 and 47 a week apart. I got that right here. I started highlighting it all. I started going over 46. A week later, you changed it. You know? And I don't even know what was changed because I didn't even read all 147 because I'm still on this. And as soon as I start following 147, you're going to change it again. You know, this was only a week apart. One was done in the 24th, right before Christmas, and one was done right before the end of the year. But
I think it was that the signature wasn't done appropriately, and so
I got both of them right here. If I want, I can submit these to you. I got both of them right here. This is 46. This is 47. So, and they're both inconsistent with 122H. Your rules are violating my constitutional rights. You're saying I can't even do a press conference out in the hallway without your permission. And I have a ruling in 2018 by Judge Gordon in this court that says, you know, that says that.
I've read that ruling.
Yeah, it says on argument number 2 of my ruling, that's me, I'm Mr. Brown that did that. So argument number 2 says, I don't need your permission for 122H, and I don't need judicial permission to film in the courthouse. All I need to do is have express permission from the person I'm recording. So I can do the interview with any of my friends out there in the courtroom. Yeah, enough to cover everything I had.
Myers.
Put on the record findings of actual harm.
Audio taping is allowed and the live streaming will continue. At this time, we need to go on to I'll have to ask you to leave because we are
Doing and I should have got 15 minutes.
now we're going to the motion to remove Mr. Myers. It's ready because I know he was speaking with Mr. Reds.
The change, Judge.
On the change of judge, sir, are you ready for that motion? If you were, I don't know, I'm sure you have seen my order. What I did was give you 20 minutes, to make any oral arguments that you would like, and then I'm giving the state 15, and then I'm giving you 5 minutes to rebut anything the state says. But let me make clear before we proceed that what I have read is the motion for change of judge filed by Mr. Myers. I received a response from Ms. Stiles this morning that I read, and then I had an excerpt done of the transcript that I spoke about at the beginning of this hearing because of some quotes you had made, and I wanted to see what the official transcript would have.
Thank you.
So I requested that. It is 8 pages. It's really 7. The 8th page is just a certification, but and the first page is like a heading, but so there's the other pages were parts of the transcript, and that was from a May 12th, 2025 hearing, just so the record's clear what I read and reviewed. I believe that is everything I read and reviewed. Do you need a second, Mr. Resnick, or is it okay?
They're working on something else.
Okay, that's fine. I just want to make sure. Okay, Mr. Meyer?
Point of order on the motion that Rachel or Ms. Stiles filed.
The response?
Yeah, it's technically not valid because she didn't serve it on me properly.
Okay. Go ahead with your
because I have to get, like, if she filed this with the court on the 23rd, I needed a copy on the 23rd. Because I have 3 days to respond. I've received it outside the window to even respond. That makes it stricken from the record. That's clearly in Rule 1.9 that if the motion isn't properly served, it's stricken from the record.
Go ahead, Mr. Myers, with your argument. You have 20 minutes with regard for the motion for change of judge. Anything you want to add to your written memorandum?
Do you want me to review what I've already written, or
however you want to use your 20 minutes is fine, sir.
All right, thank you. So to start with, the motion was filed based on the May 12th hearing, at the May 19th hearing, and I believe I'm allowed to introduce things that are not in the motion too, right? Because
if you've got something you think is important for me to consider.
The May 19th hearing is when the rule of changing judge has to be within 10 days of the.
Okay, I think we're okay. Sometimes the microphones do weird things.
It has to be within 10 days of the, incident, for lack of a better term, incident. I believe they call it the trigger event or something. So that would mean that the May 12th hearing, I would need to get it. Is that because
I wonder if it's your phone, Mr. Resnick. I don't know. I'm guessing. It's a guess thing. Sometimes.
Into that?
No, you can move it over if you see it. Let's see if it does that again. Okay, Mr. Myers, go ahead.
So pursuant to the rule, you have to file it within 10 days. So being in jail, that already makes it tough to get anything filed within this. There's some limitations on just being able to file, like e-file. You can just e-file, right? So May 12th, I decided I wanted to. Well, actually, it was actually leading up to that because he started denying. He denied, like, you just went through this whole hearing about 122 and you said you had no problem with 122H. So the very first hearing, he banned 122H throughout the whole entire proceedings. And that's against the Supreme Court rule. And when questioned on it, he said, I can do whatever I want. I said, well, how do you overrule the Supreme Court? He said, well, I can do whatever I want in my courtroom. And if you don't like it, give a special action. But that's not really truly how it works. As we just saw here, 122 is the Supreme Court rule. So right off the jump, we were already, but I didn't want to go to a special action after the first hearing on my judge that's going to preside over my trial. So I let that one slide. And then, a couple back and forth, he was refusing to give the bond hearing right from April 4th when it was initially filed. I know that I referred to it from May 12th, but this started April 4th. The initial bond hearing was filed by Parvin on April 4th. As of April 28th, he was still doing research. Well, what research do you need to do on a rule of procedure that's black and white? So that had us, I don't want to say at odds, but, we had a disagreement about the time frame of that, and he refused to rule on it. But then he had no problem ruling on a motion to dismiss the same day it was fully briefed. So he took, 4.5 weeks to still do research on a motion for bond eligibility that's a procedural right. And he took, 4 hours to rule on a motion to dismiss that has serious implications for both me and defendants across the state of Arizona. He didn't seem to need to do any research there. So that got my radar up, and I told him that I would be filing a Rule 10 because, I didn't feel like he was being impartial, because it seemed like the Ms. Stiles could file a recipe for an apple pie, and I could file a legally cognizable motion, and her motion would be granted. So at that point, I started to wonder. Okay, I said, Your Honor, I believe I'm gonna file a Rule 10. That was at the April 21st hearing. However, I had no way of filing it because Parvin was still my counsel, and we had to have the Ferretta hearing to get him off as being my lawyer so I could even file my own motion. So being in the jail, I have, my only remedy is to mail it. Well, I requested envelopes at the jail on April 17th. April 28th, they said they would get them to me. I still didn't receive them until May 9th, so I wasn't even able to file the original one. So that was leading up to that. The 10 days passed, and I couldn't file it. So now moves us to the May 12th hearing. So at the May 12th hearing, I had moved on from the original Rule of 10 because I thought, I just want to get this process moving. So at that hearing, we started going over these preliminary issues, and that's when the motion here began. But I want to pause right there for a second and jump ahead to the day I tried to file this motion. The May 12th hearing led to me wanting to file it. So May 19th, I come into court, before the judge is even on the bench, and I made it clear this motion needs to be filed before the hearing starts for it to be, binding. I handed it to that gentleman was in there, a different woman though, and let him know, hey, this needs to be filed before because I'm making, a request that needs to be done before the hearing. Once the hearing starts, it's too late, and it's got to be within 10 days. Everybody was aware of the spirit of what I was trying to do. I'm in custody. I'm at the jail. We had a hearing on May 12th. I go back on May 13th and write the motion. Had I put it in the mail that day, it still wouldn't have went through the mail system and got there prior to the hearing, because that was, just Monday to Friday. So if I would have put it in the mail Tuesday night, say it goes out Wednesday, it still would not have been in the court's possession and filed before the hearing on Friday. So I thought, okay, I'll bring it to court, make it clear I want to file this before the judge comes out. They made copies. They had it ready. They set it on the desk. He comes out, and right then and there, I say, Your Honor, before we proceed, I want to do the Rule 10. So he pulls the book out. Oh, what is Rule 10? He looks it up. He said, oh, it has to be filed before the hearing. Oh, you're denied. You have to do – the hearing already started. I said, but Your Honor, the spirit, you have discretion. He has discretion to overrule the Supreme Court. He has discretion to, take 7 weeks or 4.5 weeks to rule on a bond motion. He can dismiss motions within the same day. So the judges do have discretion. That's a word that gets thrown a lot with judges, discretion. So everybody back and forth where I said, well, Your Honor, I'm trying to do that. He said, I don't care. I said, well, what am I supposed to do? I'm in jail. How can I get it to you any sooner? And he said, what am I supposed to do? I'm in jail. How can I get it to you any sooner? And he said, and this is where I believe is just a cherry on the top of everything that he's done to me. He said, well, you're the one that chose to represent yourself. Well, that's right there. He's saying you're prejudiced because you're representing yourself. You're unable to do what you need to do because you're prejudiced by being your own attorney. And he's refusing to, the little bit of grace that would have took to say in the spirit of what I was trying to do, that he has the discretion. Instead, he tried to force me to have the hearing for the bond, despite me trying to file this motion before the hearing so that he wasn't the one that ruled on it. He could have used his discretion. Instead, he chose to say, well, that's the consequence of being your own attorney. No, I shouldn't have any consequences. And he should have just said, you know what? You're trying to file this. It's no skin off my back. I'm going to accept it as it because you clearly did everything in your power in custody and in here today to get it on my desk before. But instead, he just, nope, I'm not doing it. And then I said, Your Honor, you're just blatantly violating the spirit of the thing. And he said, you're misbehaving, and he removed me from court. Now there again, right there, Rule 9.
They just yanked the fucking cord. Dude, look at that. It says live stream offline. They just pulled the fucking plug. Look at that. Wow. Mid-argument, they pulled the plug on the live stream. That's crazy. I mean, it might come back. Maybe it was a fucking oopsie. Oopsie. Somebody made a fucky wucky. Like what? What the fuck? Wait, did I?
Said,
oh,
you're
shit.
Misbehaving, and he removed me from court. Now there again, right there, Rule 9.
Oh, damn. I thought I fucked it up somehow, so I clicked on it and it started to play and I had hope, but then it just stopped, so. Man. This was the worst fucking hearing ever. The audio was shit. You can't hardly hear the fucking judge. At times you couldn't hear the other participants. This is not transparency. And this is exactly why we need to be able to record the hearings. because they'll just cut the live feed whenever they want to. Look, I'll show you. I'll scroll up a little bit, and you can see where it says live stream offline. Wow. Huh. Secret chords. Oh. It's like so fucking weird, y'all. Like sometimes I feel like life is surreal and that it can't get any weirder and that it goes and gets fucking weirder. I mean, I don't know how long to keep trying to listen. Maybe I could go back to the other. My mouse is about to die too. Shit. Well, dead air sucks. So, oh wait, let me. Okay, that doesn't. Maybe I could open up my history and go back to the other courtroom. No, I don't know. Shit. Earlier, part of this was the Reluctant Prophets media hearing. So, he did get audio recording permission, or not permission, but he did notify. They just denied his request to do video. So perhaps he will have an audio recording of this. So I'd recommend y'all go check out Reluctant Prophet on YouTube for more information. Also Zwack, and of course this is a public service, who I heard about it from, and Tucson Sucks. Oh, they have a feed going? What? Oh? Oh, like, because they're there, right? Shit, my mouse is fucking dying. Okay, here, let me...
Chance to re-examine bail eligibility, the plain meaning of the word, and says two reasons you can do that.
Thank you for letting me know, Dad.
To a new court,
I moved over to Tuckfully Suck, y'all.
I was transferred to a new court. I applied for a bail eligibility hearing. It's a re-examination. Re-examine means de novo. Well, we got Metcalf going, well, I don't really feel comfortable looking over Judge Miller's shoulder. Well, no, that literally by rule of procedure and controlling case law, that's exactly what you need to do. You need to take what Judge Miller did and set it over here, pretend it never happened, and start from scratch. De novo. Review anew. Start over. De novo review. They start over. That's what that means. So he's letting the state file, like I said, a recipe for apple pie and saying, oh, well, your motion's denied because the recipe for apple pie says you don't get another hearing for bail. And that's right there. That's intentional disregard for the rules. That's not being impartial. That's being biased. That's being prejudiced against me. He's not taking my argument serious because I'm pro se. There's no other defense attorney in this court, no other judge in this court, no other defendant in the state of Arizona has to wait 7 weeks for a bail reexamination. That's a procedural right. It's a procedural right. It's not even something the state can argue against when it's a procedural right. You have the right to this reexamination. It's not, oh, well, we'll decide if you have the right to, we can file a motion and you can ask. No. You file the motion, you get the hearing. It's that simple. That's one thing. Now, the denial of the speedy trial, when he was setting the trial, I said, Your Honor, you have to set the trial in enough time to have sentencing before the speedy trial runs out. He says, no, you don't. No, you don't. That's not how it works.
And what rule is that, sir?
That's case law. It's in my motion. It's case law. It's in my motion right here. Speedy trial. Right here. That's State versus Bartlett, 179, Arizona, 109, 876, page 2D at 114. Court of Appeals, 1993. In light of the foregoing authorities, we hold that the guarantees to speedy trial found in the Sixth Amendment of the U.S. Constitution in Article 2, Section 24 of the Arizona Constitution apply through sentencing. So him saying, no it don't, no it don't, and if you don't like it, file a motion. No, I don't need to file a motion because it's literally been it's been affirmed since 1993 that in light of the foregoing authorities, the guarantee to speedy trial applies through sentencing. So when I say, Your Honor, you're not leaving enough time from the trial to sentencing, to do the sentencing, the whole sentencing, you know, you gotta wait, you gotta go through the pre-sentence, all that, before my speedy trial runs out, he says, oh, well, sentencing doesn't apply. And when I say, yes, it does, it's case law, he says, well, if you don't like it, file a motion. No, I don't need to file a motion to uphold my constitutional rights. That's not how this works. You don't, it's not, well, you have this constitutional right, and I'm going to use my discretion today to decide if you have that constitutional right. And if you don't like me taking away your constitutional right, you can file a motion or a special action and make yourself sit in jail for another however many months with no bond while the case is stayed so we can decide that you do have the constitutional right to a speedy trial. That's not how this works. And he wouldn't do that to any other attorney. He did it because I'm pro se. And so that's a big thing when you're taking away a constitutional right. And we sit here and talk about, you know, you have all these rights and you're innocent until you're proven guilty and you have this due process. Well, I don't have due process because he's telling me if you want due process, you have to file a motion to get due process. No, I have due process when I wake up in the morning. Everybody in this room does. Every single case that comes before you, ma'am, that applies to, it's a constitutional thing. It's not judge's discretion to decide if today we're going to do the speedy trial and we're going to apply it through sentencing or not. No, it's constitutional right. He denied me the constitutional right and told me to file a motion. Moving on to the jury questionnaire. He allowed the state to argue that the state would be prejudiced, which the state doesn't have a right to a fair trial. Only I do. The state does not have a right. That's in case law, up and down. The state has the right, the defendant has a right to a fair trial. The Sixth Amendment, all the rules of procedure guarantee the defendant a right to a fair trial. They don't guarantee an impartial, they don't guarantee the state to a right to a fair trial. And this, how can the state be prejudiced by the truth coming out? The state should, if the state is if their charges are based on the proper factual basis, and they're not in bad faith, and they're doing everything by the book, how could somebody talking about their case prejudice the state? No. So they were worried that if a jury questionnaire went out, people would go to my YouTube channel and see what they're doing to me. Well, how is that any different than somebody gets charged with murder and KVOA 9 does a story about them being charged with murder, and they interview the victim and the witnesses, and the state gives a little,
Mr. Mayor, you got about 3 minutes.
Right,
I gave you a couple extra.
That's really, I appreciate it. The state has no problem when a murder victim, murder suspect is on the news. They don't claim they're being prejudiced that a city of 1 million people, the jury pool is going to be tainted. What are they saying that? A couple hundred people are going to watch my channel, and then they can't, out of 1 million people, they can't find enough people to have a jury? So the state does not have a right to a fair trial. I do. And if I want my story out there, that's my right to have my story out there. And if a couple people read it and check my channel, that doesn't disqualify every single potential juror in a city of 1 million. Now, moving on to the retaliation thing, as you saw in the transcript, he said, word for word, I said, he said, we're going to have the hearing, I have a trial next week, then how are we going to have it within 7 days? We're going to come back on. And I said, no, you're going to follow the law, you're going to get off this case. He says, I don't like threats. It's not helping your case. How is that a threat? What threat am I saying? You're going to follow the law or get off this case. I have the right to file a motion for a change of judge. How is that a threat? Threatening to what? Follow the rules of procedure? And I said, was that a threat? He said, you're threatening me. And I said, you're threatening me now. And he said, no, you're threatening me. You're telling me if I don't do what you want, I said, no, I'm telling you, you need to follow the law. And he says, okay, and I need to read what it is. And I said, you don't need the law, right? So how is me saying, quote unquote, threatening? No, I was implying that I'm going to file a Rule 10 motion on him. He's saying it's not helping your case. So me telling him he's going to follow the law or get off the case, it's not helping my case, that is retaliation, flat out. Now, I realize there was a little space between me saying, you know, you're going to get a lot of complaints, and then, you know, it's not helping your case. But either way, the spirit of his statement is that he's somehow, by me implying that that he's not following the law, I believe he's not following the law, and that I'm going to file a Rule 10 or whatever, you know, exercise my rights to get him off this case. He's saying it's not helping my case. Well, there's no other way to read that and hear that, and as he's going to hold that against me. He's going to hold me saying you're going to follow the law or get off the case against me. Why would it? Because if it's not helping, that means it's hurting. So why would that hurt my case? How does me saying that you need to follow the law or get off the case hurt my case? He would never say that to an attorney. He said that because I'm pro se, and it's clearly a threat. He's calling me threatening, you know, he's using the word threat, which is a legal term, of a Rule 10, as something that is going to hurt my case. Well, how's it going to hurt my case? That's what I want to know. And he just ended the hearing. So I don't feel comfortable with a judge who's saying that it's me saying I'm demanding what I'm owed by these rules is hurting my case. So that should, because I know you said 3 minutes, right?
Yeah, and you just landed it. Perfect. All right. So, Ms. Fausto, you have 15 minutes from the order to recall.
Your Honor, Mr. Myers has not shown anything suggesting that Judge Metcalf has an interest or prejudice that would prevent a fair and impartial hearing or trial in this case. What he's gone through is just his disagreement with the judge's rulings, which is not grounds for 10-1 and for a change of judge for cause. So when he's talking about the live streaming, so that issue that he's brought up, this has been an ongoing issue in the court hearings where we have a lot of disruption before court even gets started, where we've had issues with the audio and the video streaming. As I said, even people who are going to do the personal audio, we have people that were using their phones and turning them in such a way to try to film. This is a harassment case against this victim has been harassed on social media. The people who have been coming to court are all connected with social media, so there is a concern about the victim suffering additional harassment throughout the process, which she has had additional harassment that's been done to her throughout the process with people with the calling and things happening in the case. So the court, in just ordering the live stream and not having people audio record, is because people weren't complying with court staff. There was no way to monitor to make sure they were only audio recording. So the court made sure it was available to the public where they could record it from as they wanted with the audio stream, but then they weren't able to then film the victim or film anything they weren't supposed to be filming. And talking about the no bond hearing, there was no bond hearing held in this case. It actually took place over 2 days. There was testimony given at the no bond hearing. There were exhibits presented at the no bond hearing. So a full no bond hearing did happen. So Mr. Myers is referencing 7.4 when it transfers, but he's not indicated any change in circumstances warranting another review. I think he's under the false impression that this court is holding 2 no bond hearings every time somebody's held without bond, but that's not the case. It's extremely rare that after a first no bond hearing is held, that a second one is held, because there's usually nothing new that would be presented at it.
I'm not aware of any. Are you? Just because I obviously
I haven't. I'm sorry.
I just wondered if you were aware of any where no bond had a second no bond hearing. I'm not aware of any, but
no. No, I cannot think of a single case where somebody has had a second no bond hearing. And in this case, he was indicted on the 2 felonies for which he was held without bond. So those 2 felonies are still in place and have been the entire time. So I think he just has this, he sees it in the rule, but in Rule 7.4, it's not mandatory, it's not shall, it's may. And that's very different, and I think if there were some material circumstances that would warrant a no bond hearing, that could potentially happen, but there are none in this case. And when he's referencing the time frame when he was with, where Mr. Carbon was representing, when Mr. Carbon had filed a motion, we had the argument on it, and then Mr. Carbon contacted the court and asked the court to withdraw it from consideration. So then the court stopped considering it until then Mr. Myers filed his own. But then the court wanted time to be able to review Mr. Myers' pleading and set it for a separate hearing. And so that's the time frame is actually very short from when the court was setting it for when Mr. Myers had actually filed his motion. Regarding speedy trial, I think Mr. Myers just doesn't fully understand there's this the time limit for speedy trial to get the case to trial, but then there's a whole separate time frame for sentencing that has its own speedy trial, per se, under 26.3, where it has a separate time where it's mandatory when the sentencing. And I think Mr. Myers just may not understand there's actually two separate time frames for that. But regardless, the date for the trial in this case is set well within speedy trial time, as I noted in the motion. And so there's nothing in this case that's indicating that Judge Metcalf has any bias or prejudice. It just seems purely that these are disagreements with the judge's rulings. And so for those reasons, I don't think he has met his standard. It is his burden to show that this judge should be removed for cause. And he has not given anything other than disagreements with his ruling to support his argument. And so we would ask for it to be denied.
Ms. Stiles, were you present on the May 12th? And I believe Mr. Myers said May 19th hearings.
When it's over, I left my
He
stuff in your car.
said that he
Need my keys. No,
filed wrote
I
the
can go do it
motion
right
right
now.
after the May 12th hearing, which corresponds with the transcript. And then on the May 19th hearing is when he provided the motion. Were you present at those?
Yes.
Okay. He indicates that he felt that, and by he, I should make that more specific so the record's clear. Mr. Myers seemed to indicate that Judge Metcalf was denying his motions or not setting his motions or delaying setting his motions. He kind of used a variety of things because he was self-represented versus if he were represented. Did you notice anything in Judge Metcalf's rulings that appeared to be treating Mr. Myers differently because he was self-represented versus being represented by an attorney? Or in his actions in court? Doesn't need to be a ruling.
No, Your Honor. I think with reference to the filings in court, Mr. Myers does have advisory counsel, so he has the ability to get documents to his advisory counsel in advance of court, where his advisory counsel can assist him with filing things prior to coming to court. And so I don't think it was an issue with the judge having an issue that Mr. Myers is representing himself, but he does have a mechanism through his advisory counsel in which to file things without filing them and handing them to the clerk in court. And in court, there's some confusion about what they were filing. One of the documents Mr. Myers had filed prior to that, actually, it was his motion for the redetermination on the no bond hearing. Mr. Myers, when he gave it in court, it never actually got filed. And so the next hearing, I had to actually notify the court that it actually wasn't filed and it wasn't in agave because of that problem. And so I think what the judge is indicating is he has advisory counsel to assist him with that. He's just not utilizing it.
Okay, thank you. I wanted to verify your. Mr. Myers, Ms. Stiles did not use all of her time, so if you want a little extra, I can give you 10 minutes for any rebuttal comments you'd like to make.
Thank you. The first thing is advisory counsel is not my secretary, he's not my paralegal, he's not my law clerk, he's advisor. When I need advice, I ask for advice. There's nothing in the procedure, like the agreement of advisory counsel where I call him up and I say, I need to file this motion, can you pick it up at the jail and go file it? He is not my secretary. And the state keeps trying to pigeonhole my advisory counsel as my secretary, my law clerk, and my runner, for lack of a better, like they use runners to bring motions over from the building to the court. That's not his purpose. He's there to give me legal advice. He's not there to file motions on my behalf. The motions are, I'm required to file the motions. I write the motions, I file the motions. He's not my secretary. And she's been saying this throughout the whole trial, how, well, he's getting his due process at the jail. I know he has no way of defending himself at the jail, but he has this advisory council who can do all this for him. No, they can't. They have other cases. They have other things to do. They don't have time to sit around and take hours out of their day to come run my errands or file my motions. And furthermore, how would I get it to him unless they come to the jail? So what do I do? Call up Resnick and demand that he comes to the jail and pick this motion up and take it to court and file it? He's not under any obligation in his agreement as my advisory counsel to come to the jail and pick up motions and take them to court and file them. He's there. His obligations are to provide me with sound legal advice. They got to get off this. And you know, she filed a notice, and you know, I don't even know why you asked her opinion really, because you didn't ask my opinion.
I was trying to understand. I understood your opinion to be that you considered it and those things, and I just wondered if she saw something different in the way he was treating you than he did people with counsel. That's all.
I mean, but that's her opinion. What do you think she did?
And that's all. Honestly, I didn't know what her opinion was, so that's why I asked.
Well, her opinion is anything against me is against me. I mean, now I want to really talk about this bail thing. I know you said you've never seen it. Well, that's shocking. For 14 years on the bench, you haven't seen this when it's clearly in the rule and there's a bunch of case law and the motion contains case law, and their response was a recipe for apple pie, which talked about a different court, and they literally changed the wording of the rules in their reply to gaslight the court into not taking my motion seriously. Why would it say that if you're transferred to a court, you can get a new hearing? It doesn't say, and there's new facts. It says, if transferred to a new court, comma, now we all had to pass English in here to get our college degrees. Well, a comma is not an and, okay? If it said, transferred to a new court and new material facts, it wouldn't have a comma, it would have the word and. It says, if transferred to a new court, comma, if new material facts, or something about that applies to the conditions of release, which don't apply, you know, they can't pay the money or something like that, which doesn't apply. There's plenty of case law that says you get it. Why would you get re-examined bail eligibility? Under what pretext could you re-examine bail eligibility if there wasn't another hearing?
City
The
Hall.
whole point of the wording is, if it's transferred to a new court, you can re-examine bail eligibility. So if you've never seen it, I don't know how, because you clearly have the right to file a motion to re-examine bail eligibility, and then when you look at the case law, how is that interpreted? It's a de novo review. Well, a de novo review for somebody that is not held eligible is a new evidentiary hearing, and there's case law on that, and she took my case law in her motion, and she responded, and she made up her own version of what it said, and she failed to even address the merits of the most binding statement in the Rule 7 motion, which was the Mendez versus Robertson case, where it clearly says 2 instances is or, you know, transferred or new facts. She completely ignored that in her motion. I mean, her motion, we're not even hearing on that right now, but it's literally a recipe for apple pie. It's not a response to what I wrote. And absolutely, positively, you can file a motion and have somebody who's held without bail, because that's the whole point of having a re-examined eligibility. There's only one class of defendants where we re-examined eligibility. Every single defendant is eligible for bail as a matter of right, except a very limited group that are held without bail because of the class of their crime. So if you're going to re-examine bail eligibility, well, everybody other than those people are already eligible. So clearly, it's intending for you to re-examine people who are not held eligible. And the case law supports that, and the case law says that when you examine bail eligibility, it has to, the only way you get due process when the state's trying to hold you without bail is with an evidentiary hearing. She turned that into something completely different in her response, and the court just buys right into this. I'm not saying you, ma'am, but I mean, you just asked her, have you never seen it? Well, that's scary. I'm scared now. I'm really scared because the whole world knows that you're entitled to a bail evidentiary, a re-examine hearing, if it's transferred to another court. The rules allow for substantive review whenever the person's case is transferred to a different court. Rule 7.4 shall be held on the record as soon as possible. You know, right to due process. It's all in the case law. How is it not a rule that you're entitled as a matter of right for it? I don't understand what I'm reading. We all passed English, like I said. She trains a term, may, right? So may. Well, ma'am, people could ask. Ma'am, you ask your teacher, may I go to the bathroom? Yes, you may. Or you ask somebody, are you going to the beach today? Well, I may or may not. There's absolutely multiple definitions of the word may, okay? There's when it says the court may, yeah, that's, well, I filed the motion, can we have my hearing? Yes, we may have your hearing. It's not, well, we may or may not have your hearing. This is not English, this is law. It's not surpluses. It's not, you know, an English competition test. It's comma. And she keeps saying and. No, if they wanted an and there, if it required a change of court and new facts, they would not have a comma there. They would have the word and. So then anybody reading that at a 6th grade reading level, which the rules are, or maybe 8th grade, they would read, okay, so the conditions of getting a new bond hearing are transfer to a new court and material facts. If they wanted it to say that, it would say that. And Metcalf already got called out in the appeals court for not understanding the plain language of the rules. It literally says when the court is re-examine means de novo. How could you have any other, how could we examine, let's give her argument some food for thought, which we shouldn't even do, but let's do it. Well, how could you have re-examination of bail without another hearing? The rule also says conditions of release. Well, I'm not asking to review my conditions of release because I don't have any conditions of release because I've been held not eligible for bail. That means we're going to take the part of the rule that says re-examine bail eligibility and we're going to re-examine it. So we're going to have a new hearing because if you don't have the new hearing, you didn't give me a de novo review. So I don't understand what I'm reading that they're not, I mean, I know that the whole point, the trick of law is, my wife's an attorney, who's a law clerk for this court. So I understand, she tells me all the time, lawyers get paid to lie, right? Lawyers get paid to twist your words, lawyers get paid to write stuff on paper that doesn't make sense, that just sounds good.
You have thought about, well, I had 10:18 to be stopped, so about 11 minutes, but I'll give you another minute.
Okay. I'm just
I want to give you
this isn't the bail eligibility hearing. I just want a fair chance to, because if the state has no problem meeting their burden, what are they so scared of? Why wouldn't they just come in there and show the same evidence and rubber stamp it? It's because I had a counsel, I wanted to continue it, I wanted to represent myself at the bail eligibility hearing, the counsel asked less than 5 questions, I didn't get to testify, we didn't present any of the evidence I wanted to present, so they know that if I get this bail eligibility hearing, that I'm going to handle it differently than the first one, and that I'm going to get bail because there is no way for them to meet the burden of proof evident if I'm asking the questions. They just, and they had Tracy Miller, who was working at the prosecutor's office a few months before this, and is friends with them at the U of A. I mean, I know you worked at the prosecutor, but you worked under Barbara Wall, who would never bring these charges. And so I know you have a different, I'm not lumping you into that same category as Tracy Miller. And I also tried to get rid of Tracy Miller under Rule 10, but Harvin wouldn't file the motion because he's got to kiss everybody's butt around here because he's got to, try to run for judge. I don't. But, this is about transferring the judge. I don't think me and Metcalf need to be in the same, I'm not comfortable. I mean, it's not just about being comfortable. I understand there has to be facts. I filed the affidavit. The judge saying it's not going to helping you means it's going to be hurting you. I mean, he removed me from court and I said, I'll behave. He said, nope, doesn't matter, remove him. There's no other way. He's just blatantly being impartial towards me. He has inherent bias towards a pro se defendant when he says, oh, that's what you get for being pro se.
Okay, I need you to.
You're good.
You're okay, all right.
Yeah.
Thank you, Mr. Meyer. I'm looking at Rule 10.1, which reads, a party is entitled to a change of judge if the party shows that the assigned judge's interest or prejudice would prevent a fair and impartial hearing and trial. There were multiple, thinking of the best word to use, I guess, multiple allegations that Mr. Myers used in his motion to show, or from his view, that Judge Metcalf had an interest or prejudice that would prevent a fair trial. As I mentioned, I did see the state's response this morning. I'm going to deny the motion to strike the response. However, I'm not going to consider the written response, but I am going to allow it to be in the file. But I have the first allegation by Mr. Myers was a denial of media coverage, and while you can agree or disagree with that ruling, I don't believe the denial of it shows an interest or prejudice that would prevent a fair or impartial hearing. The second one was a violation of the admin order. Again, I don't find that that shows an interest or violation, or excuse me, interest or prejudice that would prevent a fair trial. With regard to the speedy trial, under Rule 8, an individual who's in custody, such as Mr. Myers, must have a trial within 150 days. And based upon the calculations done by my office, he's well within the speedy trial by having a trial on July 22nd. Additionally, I think he may even be, if we're convicted at trial and sentenced within the 30 days, still within the speedy trial, because I calculate it to be sometime in the 1st of September. But even if you're right, sir, and it's August 11th, you may be a couple of days after, but under Rule 26.3, that's where the sentencing has a speedy component in it, and that is 30 days from the time of conviction. So I disagree that with Mr. Myers, and my legal basis, in case he wants to appeal this, is that the rules require 150 days under Rule 8 for trial, and then the Rule 26.3 requires 30 days for sentencing. I don't believe that that 30 days, based on my review of the rules and the law, is incorporated within that 150, but would be an extension of that. And based upon that, I do not find it is a violation of speedy trial, based on that legal analysis. With regard to denial of the bail on re-exam, again, looking at Rule 7.4C, it states, generally on motion or on its own, a court may re-examine bail eligibility or condition of release. And then there's some other information provided with that. And the last sentence is the court may hold oral argument or an evidentiary hearing. While I agree that Mr. Myers has a right to file a motion to reevaluate his conditions of release, based upon the rule, the court may or may not hear that motion. Again, I see no bias or prejudice if the court chooses not to hear a motion on review of release conditions, because that's within the court's discretion under Rule 7.4C1. With regard to the denial of a jury questionnaire, there is no right to a jury questionnaire. There's a right to a fair trial. That can be done through voir dire questions. It doesn't need to be a questionnaire sent to the jury. There's been no information or evidence presented that having a jury questionnaire gets you any more or less bias prevention, and there's nothing in the court ruling that would show a bias or prejudice or interest of Judge Metcalf for denying a jury questionnaire. And just on an aside, of the trials we do hear, a very small percentage have jury questionnaires. Threat of retaliation was the last one. With regard to the information provided in Mr. Myers' motion, it had a quote, "Don't threaten the court, it will not be good for you." That's not exactly what was said. Also in Mr. Myers' motion, he indicated that this had to do with the violation of judicial conduct, judicial code of conduct that Mr. Myers said. In referring to page 5 of the transcript that the court ordered, Mr. Myers said, and this is on line 16, that's a violation of the code of judicial conduct. The court's response was, all right, you can file a complaint then. Mr. Myers then said, you're going to get a lot of them. court said, all right. I don't find that to be at all argumentative or a threat to, against Mr. Myers if he chose to file a judicial code of conduct complaint. It's clearly within his right, and clearly the court said, go ahead and file one. On the page 7, the court does says, I don't like threats, it's not helping your case. And there is a discussion with regard to that, but again, there's no bias or prejudice shown by within that transcript or within the argument that Mr. Myers has made. So in considering all of the arguments and the law as the court views it, which I recognize is different than Mr. Myers, the court finds that there is no prejudice or interest that would prevent a fair trial shown on behalf of Judge Metcalf, and I will deny the 10.1. With regard to then, just also on the record, the court received a notice, I believe it came from Ms. Stiles' office, that procedurally today she had met with Mr. Myers before, and there may be a possible change of plea. And I wanted to address a couple issues with regard to that. One, whether there is a change of plea, because obviously that's the first question. Two, if there is a change of plea, I can certainly take that without issue, taking a plea, but then the case would go back to Judge Metcalf for sentencing. And just for the record, even if this court were to keep the case for sentencing based upon my current position, I don't have a caseload, so it would go back to Judge Metcalf if there were a violation of probation or conditions or anything. I don't know what the plea is. That's just a guess given the charges and my experience, that it would be probation available. So, Mr. Resnick, Mr. Myers, I didn't know if you caught all that. Okay, good. Absolutely.
Okay. I know. I just remembered. Is it Carl's Jr.? I wrote with him. You remember that?
Just give me a call. I'm gonna go meet him right now. And go drop
It's almost done. Just wait.
What do you say? He's waiting.
Well, Mr. Resnick,
It's about done.
I had provided to me the rule 122 and then the information provided by Mr. Kelly that's titled Motion to Affirm First Amendment Right. I'm going to order that these be filed. These were all consolidated in lowercase number, is that correct, Ms. Stiles? Were they physically consolidated or just consolidated for purposes of trial?
It's just for trial, so they're still separate.
I'm going to have them filed in the 2025-1060, just so it's clear, but I'll note that they're in both cases, or consider them in both matters for the record. Just for any appellate purposes that they may have. Okay, no, that's okay. And how did you all want to proceed? Mr. Myers? Do you want to do the plea? Do you not want to do the plea?
I had some questions about the plea itself, because the one I got, it seems like they've been going back and forth.
That happens.
Because it didn't look like anybody else is in jail.
Do you want me to?
Your Honor, I have a copy of the court's
Okay.
copy.
Yeah, if you could hand that to me. Mr. Myers, Ms. Stiles is going to hand me a copy just so I can follow what your concerns are, and if I can address them, great. If I can't, it's not a problem. You do not have to enter this plea today. If I do take a plea, I need to know you're doing it knowingly, intelligently, and voluntary, so I don't want to do it if you feel any threats. But I'm just looking at it so I can understand your questions.
Yeah, the first one didn't have that. Oh, go ahead.
And Your Honor, if the plea is accepted, the victim would just like to be heard. And then I know Mr. Myers was referencing the 85% language that was missing from the copy of the plea, so I got that inserted. We didn't realize that was missing.
Okay.
I did inform when Mr. Resnick asked me a question that obviously would still be the law regardless of that paragraph being in there, but to make sure it's clear to everybody, we put it in there.
Okay.
Judge, and the other issue that Mr. Myers had was the interplay between the operative terms of the plea and Rule 7.7 ARS 13-703. I spoke briefly with Ms. Stiles about that when Mr. Myers raised it to me. I guess the issue is consolidation, because once they're consolidated for trial, the judge is obliged to sentence the defendant as a category 1 offender, which would not make him probation available. And I guess the state could waive 703 and the court could agree to waive 703 for purposes of the plea. But I think the issue was once they're consolidated, that would be consolidated for trial. You know, occurring on some occasions, consolidated for trial. I wasn't advisory counsel at that point, so I'm not entirely sure procedurally whether or not they were or not. And so that was Mr. Meyer's concern, and I think, you know, I think he's right to raise it. I imagine there's a way to fix that, but.
Well, it looks like under the plea, I'm just looking at the top of page 2, that he's probation available on both. 2, that he's probation available on both.
Well, I mean, I don't.
I'll just get it later.
Maybe I'm misunderstanding.
What is it? It's just a battery in my charger.
So Your Honor, for trial purposes, only for trial purposes,
I got several.
Under this plea agreement, they're not
I just need the
consolidated
charger.
under the plea, and under the plea agreement, he has probation available in both matters. And so that would be very clear. It's clear in the plea agreement, and make it very clear today, and so that he would not be facing anything under 13703 for the consolidation.
So, Mr. Myers, my experience with plea agreements is they often say things that, if you got right down to the law, would make them not probation available. My example is possession of certain drugs for sale. You can possess a certain drug for sale, and if it's a certain amount, it's probation available, assuming you have no priors and all that, right? So it's a probation available. You get over what they call over the threshold, 9 grams in some cases, a certain number of pills and other things. You get over that threshold, it becomes not probation available. So a plea offer that the state may offer in a case like that is, you're facing prison, and this is obviously not you, but this is just my example. The person is facing prison for possession of methamphetamine for sale, and they've alleged over the threshold.
They plead them to the same charge, possession of methamphetamine for sale, but they don't go with the threshold. So now they're probation available. So they're making, and that one might be a bad example, but they're making, because it's meth that I chose, but they're making it probation available, even though with the amount, it would be no probation. So the same thing is true on certain cases. For example, somebody with a prior felony conviction may not be probation available, but if they drop that allegation, they're probation available. By doing this plea, saying that on the top of page 2, that the probation available term for the 5 is 3 years and for the 6 is 3 years, it is a probation available plea as I read it. So probation is available. Yes, it is available on both. If it was not available, the way the plea agreements that I've always seen will say something like, as to count 1, probation is not available. As to count 2, probation is available and it can be for 3 years. Or as to CR this, probation is not available, and as to CR this, probation is. The way this is written, it is probation available on both, and it is a contract on both. Probation is available to you. So again, that's a court's discretion. So it's not 100%, but it is available. And as are the sentencing ranges.
Right, because I know the allegation of like the priors and all that. I just wasn't sure because of the I wasn't sure if it was overlooked or, you know, because these things get a lot of copy and paste or.
No, it's a very good question. So I always look at, do the charges match? Okay, so you got a 5 and a 6 and probation periods that match with those. Are they probation available or not? And under the probation they are. The next really, I mean, it's all important, but the next really important thing to me is the special terms, because that's where unique things can be written into a plea that aren't standard. Because a lot of this other stuff is standard for everybody, regardless of what you're entering. But the special terms are not. And that has that the parties agree at the time of sentencing, and it cites a statute, the defendant shall be served with an injunction that prohibits the defendant from contacting the victim. The injunction does not expire and is valid for the defendant's natural life unless dismissal is granted pursuant to, and again, it cites that statute. So that's an important unique feature of this plea that would be different than others. I don't see him. Absolutely.
It sounds like Lane and his advisory are speaking. It's very hushed and quiet and whispered, so you can't really hardly hear anything. But that is like privilege, so I'm just gonna talk a little bit loud while they're doing that, so that they're gonna be heard, because, you know, that's privileged information, attorney advisory, client privilege stuff. So, yeah.
Because I was wondering about, you know, in Rule 7,
Yeah, go ahead.
you know, in Rule 7.2c, the rule reads, you can't release if there's a high release of prison.
Right.
And so to me, this whole case is about videos on YouTube, right? So I'm already sitting in jail and the videos are still up. So I'm charged with crime. I'm sitting in jail, alleged crime is still happening. And then I'm going to plead guilty to a crime, sit in jail, convicted of a crime, and the crime's still happening. I feel like that makes it hard for this whole court. In the sense that, you know, it must not be a crime, because I know in your 14 years as a prosecutor, you never agreed to a plea bargain where if you take this plea, you can keep committing the crime. That's never been a condition of the plea bargain, where you said, you know what, you can be charged for this crime, you can be convicted of this crime, but go ahead and keep committing it. Don't worry about it. It's no big deal.
I think I understand what you're saying. I think you can't keep committing the crime.
The crime is the video that's on my YouTube channel.
Right.
And only I can take it down.
Okay.
So I'll be sitting in prison, and the video will still be up, and the crime will still be happening. That's doesn't comport with reality.
Well, they're charging with regard to specific dates, so that's one thing. All charges have a specific date and time.
Well,
So
one is the count 1, or well, they're calling it count 14, is a
right.
period of time involving multiple videos. So I'm sitting in jail, and people are watching the videos as we speak.
Well, I think that if the state wanted to file another charge with today's date, perhaps they could do that, and that would be a whole nother legal argument. If you're asking me whether that could happen.
Well, no, I'm saying that, you know, what are we really doing here if the crime is the videos and they're not even worried about the videos coming down?
Well, sir, that's not a decision for me today. For me to...
You can release me. That's what I mean.
Oh, under 7.2. So when there's a change in circumstances, and I think the fact that you have gone from what is considered a no bond because you have something on release and an allegation, that's my understanding of why you were held no bond, is because there was an allegation of a new felony committed while on release. That's the basis of the no bond.
Presumption evident or whatever.
Right. So now we don't have that pending, right? We don't have, if you entered the plea.
If I entered the plea.
Right, yeah, so we're on the same page, great. So if you entered the plea, we wouldn't have that pending anymore. In fact, we would have probation available circumstances. I think under those circumstances, it is the right thing to consider what release conditions pending sentencing. Now, this is how I typically do that, so you know. Somebody enters a plea, similar to this, where probation becomes available when it was not available as charged, okay? So at that point, then I would normally turn to the state and ask the state for their position with regard to release pending sentencing. If it's a victim case, I ask the victim their position pending sentencing. I then ask counsel, in this case you directly, your position with regard to release pending sentencing. After all of that, I would consider whether to release or keep you detained pending sentencing. Sentencing has to occur within 30 days. I can't tell you what I would rule. I can't tell you what the state or the victim would ask. I can just tell you that that's the procedure I would use with regard to release. If I released you, you'd be released. We'd have a sentencing within 30 days in front of Judge Metcalf. If I didn't release you, you'd have a sentencing 30 days in front of Judge Metcalf. That's the procedure.
Right, and the procedure, and I understand. We know the state.
Okay, just I wanted to make sure.
I know the state would say keep him in jail, but I feel like that's making a mockery of this whole thing. If I'm saying I'm willing to plead guilty and you release me today, I'll go home and stop the harm. And they're saying, you know what? Nope, just keep him in jail. I feel like that undermines their whole case, truly, because
there are different arguments on both sides, and I've seen both made.
I'm highly likely. I'm a very low risk score. I'm highly likely to get probation. None of these prior things, I don't even have them because they're dismissed. This whole count one case consolidated with the other.
That's kind of an argument for after, Mr. Myers. If you did enter the plea, I'm happy to hear your arguments with regard to release and the states as well as
their position. And to me,
but that's something I have to consider only if you enter this plea. If you don't enter this plea, I'm not.
Oh, no, I know. I'm not asking you to rule on that now. I'm just.
I want you to enter the plea because
I know.
Think it's the best for you, not for any other reason.
Well, it's not just when you take something like this, it's not just what's best for me. When they're hammering down your throat about the victim, I got to take in consideration, if I'm not a heartless bastard, the victim and this kind of thing. So if it's okay.
That's nice to hear.
My videos are causing they're saying that even when I make a phone call from jail, she gets calls. So my videos are up. People can watch them. People can contact her. People can, quote unquote, allegedly harass her. While I sit in jail charged for the crime, other people are doing the exact same thing that I'm charged for every day. They're not charged. And so what message does it truly send to victims everywhere, or to people that are watching the court right now, or 375 years of First Amendment, or I've never seen a case where somebody's been charged for criticizing the government in my life. I've just read 14 hours a day of case law. I know Barbara Lawal would never charge these charges. I know that under Pima County since 1976, there's never been somebody charged for criticizing the government.
So, Mr. Myers, I just need to know today, and I can give you another minute to check with Mr. Resnick.
I'm just trying to figure this out because I don't want to make a mockery. The point of this is, we're making a mockery of this whole thing. If the victim is saying your videos are harming me, but you can leave them up. We're making a mockery of this court every time I come to court. And so, do we want the circus to continue? The state has to work in this court. I don't. Okay? I only have to have one case here. The state brought this circus to town. The state wants this circus to be over in one hand, but they're undermining their own argument by saying, well, we'll offer you probation and you can go back to the community, but you can't go back to the community yet.
So, Mr. Myers, the state makes plea decisions for a couple of reasons. And you're right. The benefit they get is they get a conviction. They don't have to take you to trial. That's their benefit. Your benefit would be less prison sentence than you would get if convicted at trial. Everybody's got a benefit and a loss when they do a plea agreement of some kind. I am happy.
Doesn't the victim come into this? It's not just the state and the defendant?
The victim had the right to be consulted about the plea agreement, the right to make any objections that she wishes to make to the plea agreement if she had any, and the right to be present. She gets that right.
This is not a victim, quote unquote, victimless crime. So there's a victim in this case, right?
Right, and she has the right to be present, the right to know about the plea, and the right to object to it.
I'm just trying to understand. Okay, so the victim is being victimized, allegedly. But they want to keep me in jail with the videos up and continue the victimization. That undermines their whole, I read a lot of case law over the weekend, and I haven't found a single case of a public employee being able to charge somebody with harassment.
And you're welcome to take it to trial, Mr. Myers, if you think you have a valid case. by all means, I mean, it's very important that you exercise your constitutional right to a trial if you think that's what's best for you, or you think that that's what's right. Knowing.
I mean, to me, reading the rule, the state we can stipulate to my release. And they won't.
Well, the state doesn't have to, though.
I'm not saying they do. I've already talked to them about it.
Yeah.
So I just don't really know, I'm vacillating because.
I don't think you should enter this plea based on release or non-release.
Well, that's the only reason I would do it, because, I mean, I'm only getting, trial's July 22nd.
Right.
I'm going to go sit back at the jail for 30 days, give up all my rights to an appeal, stop litigating the case, not get my depositions, not force the victim to come under the scrutiny of the witness stand, not catch the detective under, he perjured himself at the grand jury. I'm giving up a lot of strong leverage too if I take this. And if it's just, well, you'll get less charges and still go to prison, well, that doesn't benefit me, because then I don't have the appeals. So I'm giving up. I would rather go to prison for more time and have all my appeals, because all my appeals say that I'm not guilty. All the case law says I'm not guilty. So if we were just deciding this on case law, this would already be dismissed. But you can't get into the facts, before trial.
Right, and you alone have to make this decision as to what's best for you, whether entering the plea or going to trial is. And you're right, you give up rights, the state gives up things as well at a trial, and you both get things at a plea. That's the way, to me, a plea agreement is like any other contract you enter. It may sound silly to compare it to a contract to build a house or something, but in reality, or to buy a car, in reality, in some ways, it is the same. You get a benefit. You do it for those. It's the same. You get a benefit. You do it for those reasons. The seller loses something, the car. You lose something, cash. So it makes it very simplistic. But a plea agreement really should have a benefit to both, and there's something you both give up. This, on paper alone, shows a benefit to the state to me and a benefit to you. That's just paper alone. That's not the basis behind the paper, like the arguments and legal arguments that you believe you have, Mr. Myers, and whether you think you can win this case either in trial or on appeal. That's a separate issue. But it is important that you consider the fact that you could get convicted in a lot more prison time. And Ms. Stiles, if I'm correct, if he's convicted at trial, there is some mandatory prison time, correct?
Yes, Your
Of
Honor.
everything as charged.
So he has prior convictions. They're old, but they would make the prison mandatory even if he's just convicted of one felony at trial. And then because of the separate dates, he faces the possibility of stacking, and that they would be then treated as the Category 1 repetitive offender. And then on the second case, he would also have the on-release allegation, which would then
Presumptive.
So yeah, well, no, it adds 2 years.
2 years. And that 2 years is flat, isn't it?
So, and that's.
Yeah, that's am I right, Mr. Resnick, that 2 years is flat? Okay.
Yeah, I'm aware of all that. I just don't see the benefit to the state. I mean, they got to prove.
Yeah.
Well, so the benefit to the state is if you enter the plea.
That's something I didn't do.
Well, if you didn't do it, sir, you can't enter a plea.
I
So.
definitely didn't do it. I'm just entering the plea. The only reason I would enter the plea is because I haven't seen my parents in 5 years, and they had been planning to come to Tucson next week for 8 months anyways, which the state is aware of because they listen to all my calls and read all my messages. So, I mean, the only.
Well, they'll be here then either way.
Beware.
Whether you go to trial in July or whether.
No, I mean, they're coming to visit next week. They live in Michigan.
But I thought you said for 8 months.
No, we've been planning this
Oh,
for 8 months.
I apologize.
This is something that was in the works for 8 months, and now suddenly I'm in jail. They're driving across the country to visit me and my sister. They're 70 years old. The state is going to argue against me being released today if I enter this plea. So to me, the benefit would be that I get to see my parents who I haven't seen in 3 years. I get to go home and take the videos down and direct the attention. Then the videos will be, oh, look, the judge did the right thing, or the court did the right thing, and they let this guy out of the gulag because he should have never been there. But it doesn't seem like the state I feel like the state is disingenuous, you know?
Your Honor.
Well, so, and yeah.
I think Mr. Myers is hoping that I'm going to change my mind and agree to his release. I can tell you that will not happen at there. So he can keep talking about it and throwing that out there. It will not change. And I've stressed that to him. My belief is that he needs to be in custody until sentencing. He had his arraignment on the first case, and that very weekend he went and committed new felony offenses against this victim.
Allegedly.
So I understand it's alleged. I understand this is a state's argument.
And so, you know, I have concerns if he is not being supervised by probation. We've made it probation available, but probation comes with a lot more conditions of release and a lot more monitoring than does pretrial services. And pretrial services, him being out before was not enough to stop him from doing this. And so if he's giving this speech right now, hoping that I'm going to change my position on that, I can tell you it's not going to happen. And if he would like to go to trial, we are ready and, you know, to go to trial, so he can make his choice. So if he wants the plea, it's available to him today. If he doesn't want the plea, we're able to go to trial.
Yeah, I don't think I was trying to get.
Can you do it? Hold on 1 second, Mr. Myers. Can you do a Donald record today? Have that information? It's okay if you can't. I just wanted to.
Yeah, I'm starting to write it out. It, you know, it's a little lengthier. But.
I know. I know it's a lot of math.
What is that?
Okay, so the Donald record, that's a case, and it basically says that. So if you accept a plea, I have to find that you knowingly, intelligently, and voluntarily. If you reject a plea, I need to know that you knowingly, intelligently, and voluntarily rejected it. You can't knowingly or intelligently reject something you don't know what you face, for example. So if you have no idea what you face being convicted at trial, how are you knowingly rejecting the plea agreement? So I need to know what you're facing at trial. And I've not done the math, so I asked Ms. Stiles if she had what you're facing at trial. So I can ask you to compare what you're facing at trial with this. And if you want to reject the plea, again, no problem. I'm just knowingly, intelligently, and voluntarily getting on the record that's how you're rejecting it. Does that make sense, Mr. Myers?
Yes, and I don't think I'm not trying to get her to change her mind because it's up to the court. It's not up to her.
Right.
To release me.
And you know she's going to argue that.
Of course, I already know that. That's why I don't even know why she grandstanded. But the point is that I got to consider the rest of my life and the felony convictions. I own businesses, you know, employment, things like that, versus, you know, sitting in jail a little bit. I'm going to already be sitting in jail another 30 days if you don't release me, which I'm sure you'll just go with whatever the state says. And then I could have just sat in jail a little bit longer and been found not guilty on all this and had a giant lawsuit against the city of Tucson, the police department, and all that. And, you know, giving up all my appeals, I just don't understand how this plea bargain benefits the victim.
Well, it doesn't have to benefit the victim.
When the victim's not even being harmed, then.
But the victim, so Mr. Myers, the victim has to be aware of the plea agreement and has the right to reject the plea agreement. The state can offer a plea agreement regardless of how the victim feels about it. So if the victim doesn't like the plea agreement, and I've had victims not like the plea agreement both ways. It's too harsh, it's too easy. I've had both from victims. So the victim has that right. The victim doesn't control whether a plea offer is made. That's actually controlled by the state.
Can I have 1 moment, Judge?
Sure. It makes sense.
Can I have 1 second, Judge?
Sure. My understanding, just so you know, Mr. Wesley, because our mute buttons aren't working real well, so you might want to move the microphone if you do need to say anything.
It seems kind of like I don't know where this microphone is in this courtroom, but it seems way closer to the defendant and attorney's desk than the judge's desk. Because at times the judge sounds like she is like 50 feet away, in a tunnel. And here we can hear Lane's advisor whispering. Like I'm literally talking over it just to make sure that there's no, like, information being leaked out that shouldn't be. Because, like,
Sure.
yeah.
Do you want this on the record? That's John's. That's just for John.
Oh god, these microphone sounds are killing me. Dude, there is nothing fucking worse than like these little fucking, like, rubbing a fucking thing on a microphone or like adjusting it, and so you hear like the fucking, oh, I can't stand it. It's just, oh, it's one of my pet peeves. Like, put the mic in one fucking spot and then leave it the fuck alone, right? Like, you don't need to be fucking fondling microphones so fucking much. I would love to find out from somebody who's been able to go into the courtroom. Where is this microphone located? It seems very suspicious to me. Hey, at least the feed came back though, right? Thanks to Tucson Sucks for having the feed going when this one was down. There was a little bit of an interruption. Man, what a shit show today's hearing has been as far as the stream audio quality goes. Inconsistency and being able to hear things. It got eerily quiet. Yeah, most other courtrooms I see that like stream on YouTube, the primary microphone is at the judge's desk. And then, like, if there's any kind of conferences or what is it, like, calls to the bench, they play like white noise right there by it. That way that conversation can't be heard. So I don't think this feed, I don't think the microphone is placed close enough to the judge's desk, in my opinion. Anyway, if you're watching this later, comment down below. What do you think? Good or bad? Yay or nay? I welcome all comments.
All right. I mean, should I?
Yeah. Oh, sorry. So now my attention's on you, Mr. Myers.
Good?
Yes. So we'll go, just so we're formal, we're going back on the record. So, and I know you had a chance to talk to your advisory council. What would you like to do at this time, Mr. You want to do the plea? Okay. If you want to do the plea, I need you to sign it. Does he have an original one?
This is the one that doesn't have the. I've got it in front of me.
Oh, you've got it? Okay.
I just need to sign it too.
Okay. And then,
Your Honor, the victim does want to be heard at some point.
okay. Do you want to be heard before, ma'am, or after?
Do you want to be heard before she goes through all of it, or do you want to be heard before she?
If you have any objection, I'd rather hear you before, but if it's something else, then I can hear you after, whatever's good with you.
Not really an objection, more a consideration.
Okay.
I'm open either way.
Thanks.
So she speaks before we do this?
I can do it either way. Would you be more comfortable if we heard from her first?
Would I be more comfortable?
Yeah.
Whatever makes her feel best.
Ms. Walker, you want to go? Let me know your concerns or what you would like me to consider, ma'am. And it's Ms. Walker, correct?
Yes.
Okay,
yes.
thank you.
Your Honor, thank you for the opportunity to speak. While I understand that specific sentencing details, including any prison time and probation conditions, will be determined at a later stage, I feel compelled to make my position clear now, as these conditions are critical to my support of the proposed plea. I appreciate that Mr. Myers appears prepared to plead guilty to 2 of the many crimes he has committed against me. In doing so, he is acknowledging that his conduct was not protected speech. It was a sustained and calculated pattern of stalking and harassment that caused serious harm. These were not isolated or impulsive actions. They were intentional, repeated, and profoundly damaging. However, while I do support this plea agreement, I have serious reservations. Mr. Myers has shown time and again that he is unwilling to follow court orders. Based on his behavior, I do not believe that he's capable of complying with probation without strict and ongoing oversight, along with serious consequences if those terms are violated. Any plea Mr. Myers enters should ultimately be accompanied by a period of incarceration, which I understand will be determined by Judge Metcalf, as well as strong enforceable probation conditions that are specifically designed to protect me, my family, and the community. These measures are necessary not only to reflect the seriousness of Mr. Myers' crimes, but to ensure that I and those close to me can move forward in safety. When the court considers sentencing, I will be prepared to request conditions that provide meaningful protection. In the meantime, I respectfully ask the court to take this into account as the case proceeds. Thank you.
Thank you very much. Mr. Myers, are you still ready to go through with the plea? If so, I just need the signed copy, and I believe...
Serious...
If you're ready, if you sign the plea, then I'll make sure Ms. Stiles signs the plea, because my understanding is she has not either, and I need her signature as well. And then I would go through the questions with you.
Oh man, that was some...
Woo wee, woo wee,
All right.
I just need the signed copy whenever you're ready. And then, as I mentioned, I also need that from Ms. Stiles.
Make sure we got the right one here. Yes.
We still got.
Oh, I gotta ask you a lot of questions. Yeah.
Oh, yeah.
We're not done. There's, Mr. Myers, I have a series of questions to ask you. Oh no. Oh no. If at any time you don't understand my questions, you need to let me know. Anytime you wish to speak to your advisory council, you're welcome to do so. Just let me know so I make sure you can do that respectfully. Sometimes I talk fast, so if I get going and you feel like you're missing something, let me know.
Say I do too.
All right. Can you state your full name for me, please?
Lane Myers.
And do
My middle name?
Sure, it's on here.
Jeffrey Myers.
And do you read and understand English?
Yes.
I have to ask everybody all these questions, so just bear with me. Have you had any alcohol, drugs, or medication in the last 24 hours?
No, definitely. In the last 24 years.
I need to let you know if you're not a U.S. citizen, entering a plea agreement can affect immigration status, resulting in you being deported or removed, preventing you from obtaining U.S. citizenship or legal status, even if later these charges are dismissed. Do you understand that?
Is there a way to stipulate deportation as part of this agreement?
Well, and I can tell you if you're not a U.S. citizen, it can affect immigration status. That's all I can tell you, and I need to make sure you understand that.
I'm a U.S. citizen. I just want to know if I can plea
bargain. I think, well, other than being on probation, I think you're always free to leave the country. Probation may inhibit that if you're on probation.
If the
all right.
Amendment doesn't apply anymore, I want out.
According to the plea agreement under CR 2025-1060, you're admitting to amended count 14, stalking. Oh, I did want to hold on.
Yeah.
Make sure I've got my stuff correctly here. And that's class 5 felony. And then CR 2025-450 to amend count 1. Aggravated harassment with court order in place and class 6 on the class 5 is a possible prison sentence between 6 months to 2.5 years, and on the class 6 between 30 to 2 years. In a prison sentence,
you would have to serve at least 85% of before you could be released, and 1 day for every 7 days served in what we call community supervision after your release. Probation is available on both cases and both charges. On both the Class 5 and the Class 6, probation can be for up to 3 years. It can also include up to 12 months in the Pima County Jail. There's a potential fine of $150,000 plus surcharges. And as to the special terms in CR 2025-1060, the parties agree that at the time of sentencing, pursuant to ARS 13719A, you shall be served with an injunction that prohibits you from contacting the victim. The injunction does not expire and is valid for your natural life unless it is to ARS 13719. Without any restitution, you could the victim for any restitution loss, so that would be loss. You are also giving up your right to a direct appeal, but you could challenge this with petition for post-conviction relief. Do you understand all those possible consequences?
Yes, ma'am.
Did anybody make any threats to you or promise you anything we didn't discuss report today that you can enter this plea? What we talked about before. Because I did talk to you about procedures when you were talking.
No.
But other than that, did anybody talk to you or promise you anything to get you entered this plea or make you any threats to make you enter?
My wife.
Okay. Well,
I'm just kidding.
All right. So you don't feel threatened or coerced to take the plea. Is that correct, Mr. Myers?
No, I'm doing this.
Okay.
I know. I got a plan.
All right. And did you sign this plea agreement?
Yes, ma'am.
And you signed that after we talked about things here today and after you had the chance to speak to your advisory council, correct?
Yes.
And do you feel that it's in your best interest to enter this plea given all of the circumstances and surrounding consequences that you potentially face?
I'm taking my advisory council's advice.
Okay. And so going on to amended count 14, it refers to September 12th of 2024 through approximately, and this is on or about, so it doesn't have to be the exact dates, but on or about September 12th, 2024 through February 22nd, 2025. Did you intentionally or knowingly engage in a course of conduct directed towards Shannon Walker, which caused her to reasonably feel for her safety and or the safety of her family?
Well, the state can lay the factual basis.
Okay.
I'm not going to lay the factual basis, he's gonna need to lay it.
So was it emails, phone calls, things like that, Mr. Myers, that you called or sent to Ms. Walker?
That's up to the state to lay the fact in the court to find.
Sir, I need some facts from you. I'm trying to give you some pointers, Mr.
You want the
Resnick.
facts from me?
Let me see, Mr. Resnick might have something that I can follow up. Hold on.
If you want me to lay the facts.
Shocking distress / fear under count 1.
Well, the allegation is on, like you said.
Count 14, excuse me.
You're talking about the first one, 1060. So
Yes, sir.
it's saying through September 2024, or 12 through September 22nd. So the factual basis is that on June 4th, I was arrested for booing at the city council meeting. Matthew Walker started prosecuting me. I began investigating him. I determined that his wife was a government employee for the state of Arizona who worked at the law school and worked with Matt Walker on special projects between the two entities. At that point, I made a YouTube video saying, I made a phone call to Miss Walker and I advised her that her husband was violating the law and she had an oath, and I called him a crooked ass prosecutor. And so then in retaliation, she went and had my wife, her and Stacy Jane had my wife fired from her job. So then at that point, I made a video explaining what happened about her role in that. And then I made a video which showed her government information on a government website. And at that point, she went and retaliated by coming to this court and getting an ex parte injunction against harassment by lying to Judge Walton.
Okay, well, the harassment is after.
No, she got an injunction for harassment.
Okay.
By lying to Judge Judge Weiland, and then the next day she came and dismissed that injunction for harassment unlawfully. It was issued again by Judge Walton after saying if you dismiss it, you're not eligible to get another one. She was then granted another one without testifying to any facts or acts contained in the petition. I was unaware of that until I was served the injunction, and then once I was served the injunction, I made a YouTube video showing a publicly available public court document which contained public information about a government employee. At that point, I then had a hearing with Judge Griffin in which he said all my videos that were previously posted are allowed to remain posted because it's my First Amendment right to have those videos up. He would not be ordering them taken down, so I left those videos up and I moved on from November to January when a judge in this court made me aware of the hearing that supposedly disappeared on October 9th. When I became aware of that hearing, I paid Tracy Robinson $35 for the record from the court reporters. I paid Tracy Robinson $35 for the record from the court reporters.
know how Shannon Walker committed perjury 33 times in 9 minutes with Judge Weiland, went back the next day and was somehow issued an injunction based on one alleged act, and then was told that the hearing will be sealed unlawfully. I thought that was newsworthy, so I made a video. I posted that. At that time, I had an injunction which unlawfully restricted my ability to disseminate information about government employees. I knew that it was unlawful and I was appealing it, so I went ahead and made the video anyways and exercised my First Amendment right to about government employees. And that was a 4-part series. I made 4 videos about her lies in court, Judge Walton's issuance of the injunction, despite her stating in the hearing that if it was dismissed, she would be unable to do it. She did it anyways. I thought that was newsworthy. I own a news media company in the state of Arizona, so I thought my freedom of press would outweigh the injunction. I then posted that and then moved on with life on February 22nd. On March 7th, they indicted me using the detectives lied to the grand jury, got an indictment, and then I was served that indictment on March 12th. I came to court on March 14th and was arraigned on that charge.
So, Mr. Myers, I heard you say that you made some calls to Ms.
Made one call.
A call to Ms. Walker. You did 4.
Prior to the injunction.
Right. That would be within the September 12th, 2024 through February 22nd.
Yeah, I called and left her a voicemail saying that Matt Walker was a crooked-ass prosecutor.
And there were 4 videos that you posted?
Containing the FTR that I paid $35 for from the court reporter.
Okay. And so you posted some things that sounds like you're knowingly against the course of conduct toward Ms. Walker. What I want to know is also, according to this, which would cause Ms. Walker to reasonably fear for her safety or the safety of the family. So
there's no threats.
So there can be direct threats, which would be obvious, and then there can be things that just make you feel uncomfortable.
And Your Honor, I can supplement a little bit.
She said she wasn't saying nothing. She wasn't saying nothing. Those are the facts.
Your Honor, he engaged in posting Ms. Walker's information regarding her work email, her work address, her work phone number, and then he would put it onto his YouTube page, and then he'd put it up there and he would encourage his followers to contact her, in which they did, and they left her harassing messages that also ranged from things like wanting her to be raped and killed. And so these messages kept coming in. He was made aware of these messages. He's indicated numerous times that he was aware that his followers were leaving these type of messages, and yet he continued to put up her information during this time, causing those followers to continue that contact with her. So he had initial contacts with her where he left her that message. He went to the law school looking for her, but then he also would use his social media to encourage his followers to continue that conduct.
Do you understand that all of that would have made her fear for her safety, Mr. Myers? Okay. Then do you have any other reason why she would fear for her safety?
Because she doesn't understand that she took an oath under ARS 231.
Taking an oath doesn't mean you have a right to be harassed.
I didn't harass her. The allegation was that other people did, not me.
So,
I didn't promote anybody, and I didn't encourage them. There's no factual basis for me encouraging them.
Okay. Thank you, Mr. Meyer. At this point, I can't take your plea because I have to have a factual basis, and part of that is that Shannon Walker to reasonably feel for her safety or the safety of her family. And if you can't, and I'm fine with that. If you can't do it, just so you know.
I'm just curious if you're asking me to admit to that, because the state even just said that other people called her.
And that you were aware and you continue to post her address and information, and you continue to encourage people.
U of A posted her address.
Okay.
So what do you, I'm confused because I let the state, I said the state could do it, and they refused to do it, and now they're disputing what I did.
Mr. Resnick?
I guess the issue is, Judge, what Mr. Myers did was he posted publicly available forward, publicly facing information that's on the U of A's website. So obviously he has no control over third parties. He can't stop them from doing whatever.
I also didn't encourage him. That's a lie.
And yeah, I mean, again, if I cover a news story, if I were a news organization and I cover a news story, we deal with it all the time. You know, you may wind up getting phone calls and comments and things from third parties who see the news story, but it's not like KGA 9 or TV 13 have any control over that. And certainly they would never be held liable or charged with, you know, harassing a private individual.
Then I don't have a basis.
No, I agree, and that's part of the First Amendment tie-in here.
Yeah.
I mean, you're allowed to use the record. You're allowed to use the grand jury transcript, and if you read the grand jury transcript.
Sure, I won't. First of all, I don't have it in front of me. It gets sealed. I can't even pull it up on Agave.
Oh, I thought that the rule was that you could use anything on the record.
I can pull it up and all of that, but even if I do that, I have to have you agree.
That what?
And that all those facts that are in there are accurate.
In the grand jury testimony.
And you've already told me you don't agree with that.
You're saying you agree. Well, what the grand jury says and what Rachel Stiles just said are two different things.
What I have to have you say to me, Mr. Myers, is that on or about September 12th, 2024 through February 22nd, 2025, you knowingly engaged in a course of conduct. I think I have that because I think I have emails that you've agreed that or a phone call you've agreed you've made and multiple postings for videos. So I can take that as a course in conduct. So I've got that part of it, which would cause Shannon Walker to reasonably fear for her safety or the safety of her family. I have to have something.
That's subjective, though.
Well, I have to know that you agree that what you did made it reasonable for her to fear for her safety or the safety of her family. And I don't have that right now, and I'm okay not having it. I'm not asking you to give me something you can't say, but if it's reasonable for her to fear based upon these phone calls and the things that she was getting that you initiated by putting her information out there, it may have been a public-facing website, but you put it out there in a different way. If you would agree that that reasonably resulted in her having a fear for her safety, then I can move forward to the second one.
You're asking me to admit to allegations that are not made against me.
Okay. And I'm just fine if that's how you're viewing it,
You're saying
Mr.
that
Myers?
you want me to say that I believe Shannon Walker, it was reasonable for her fear for her safety based on my conduct. But the state just offered evidence of other people's conduct saying they would do this or that. I never said I would do this or that, and I never encouraged people to do that.
So, Mr. Myers, so the same thing happens to me again taking a drug plea. It's charged for sale, the plea is for sale. They can admit they possessed it, but they deny that they did it for sale. I cannot accept that plea. It may be a crime to possess a drug, but I have a plea agreement I have is possession for sale. I have to have both count. I have to have the drug and I have to have the sale. In this case, I have to have the course and conduct, which I'm comfortable with. And then I have to have, which would cause Ms. Walker to reasonably feel for her safety or the safety of the family. I have to have that. So if you can't acknowledge that your conduct would reasonably result in that, I'm okay with that, but it just means I can't take the plea because I have to have both factors.
So my question is where is that stemming from? Because the rule says that the court needs to find the facts, not that I need to admit to them.
Well, I need to have a factual basis, and I get that from individual. Okay, and then I asked you to agree to it, and you didn't agree to what they said.
Because the rule doesn't say that I'm required to admit anything.
So, sir, I will not take a plea.
That's a personal, that's your personal
that's the way. My view of the law is that the defendant has to enter a factual basis and enter a plea, and they need to do so knowingly, intelligently, and voluntarily.
Is that
so
your
they either
version
have
of
to.
Rule 17?
That's my view of the law. I will not take a plea just because the state rattles off a bunch of stuff and have a defendant sit there quiet. Every plea I've ever taken on 9 years on the criminal bench included a factual basis that somebody provided and that the defendant agreed to. If you cannot agree, no problem whatsoever. I just won't take the plea, sir. I have to know you agree to the factual basis. If not, I will not accept it.
So I'm.
And you're welcome to try Judge Metcalf. I don't think he'll accept it either, but.
Well, you're saying that, when you said the law or whatever, that you're saying you need it based on the law, are you saying based on Rule 17? Because the way I read Rule 17 in the case law is that the judge is required to make that finding based on the record, not on me admitting it.
No, I can look at facts from the record, and then I can look at you and say, do you agree with those facts? And if you agree, that's fine. I will not take a plea.
If you looked at the record into that, I would be more comfortable than with the state, just like you said, just rattling off some stuff and then saying, do I agree? Because what she rattled off is not what I'm charged with.
With what you did, the course and conduct of the posting of the videos, the phone call, with that, was it reasonable for Ms. Walker to fear for her safety or the safety of her family? Was that reasonable?
I don't think that she should have been fearing for her safety.
Okay, then I don't have a factual basis. So, and which is fine. Again, no problem. I am going to make sure that, Michelle, can I have you?
Your Honor, I have the Donald record because after this, like, we're going to pull the plea. So we're going to be done and we're just going to go to trial.
Then let me hold on to this for one more minute.
Because if he can't agree that him posting those videos caused those people to reach out to her and that they wouldn't have reached out to her but for him doing that, then I
think they reached out based on her lies in court.
Okay. So I think we don't have it.
So it sounds like we won't get there. So we're just going to plan on going to trial. So let's just go ahead and do the Donald.
Sure.
Then we're going to pull the plea after today. We're
Please,
just going to go.
Please listen to Ms. Stiles. Mr. Myers, I'm going to ask you some questions when she gives us this information. Go ahead, Ms. Stiles.
So, Your Honor, I'm going to go through, I'm breaking them up. They'll be consolidated for trial purposes, but I'm breaking them up into segments just because of the on-release allegation gives the 2 years extra. So in the first matter, he would have the Class 6 felony that would carry, all of this is prison mandatory because he does have prior felony convictions. And, Your Honor, he's not paying attention, so.
Mr. Myers, make sure you're listening. Okay, the Class 6, I'll go through it again.
What is it that we're doing right now?
We're getting a Donald record to make sure that you understand.
I thought you said that you were rejecting the plea.
I am. That's why we have to do a Donald record.
Oh, okay.
Go ahead.
So for the Class 6 at trial, he's facing the 0.33 years up to 2 years. For Class 5 at trial, he's got 5 of the Class 5, so each one carries a range of 6 months up to 2.5 years. And then on the Class 3, for the first case, he'd face a range of 2 to 8.75 years. Again, these are all prison mandatory, and
they could technically be stacked, correct, because they're different dates?
Correct. And then under the second case, we would have, it's increasing the range because of the fact that we have the on-release allegation. So he has 2 of those Class 5s, each of them carrying a range then of maybe 2.5 up to 4.5 years with that added 2 years. And then with the Class 3 offense, we would then be dealing with 1 on release, so then it's a range of 4 to 10.75 years. So at trial, he would be facing a minimum, if he's convicted of everything, of 4 years up to 43 years in prison.
Okay. All right. So, Mr. Myers, did you hear all that?
Yeah. Do I get to add up how much money and damages they're going to pay me if I'm acquitted?
Sir, that's not what we're doing on a Donald record. So on a Donald record, I need to make sure you understand that at trial, if you're convicted as charged, so it has to be, this is with everything. The minimum you face would be 4 years in the Department of Corrections, and the maximum would be 43 years. And that's because they can take the first Class 6 and sentence you to 2 years on the maximum level, 2, and then there's 5 Class 5, so they can each be 2.5.
Actually, those Class 5s are only Class 6s.
Okay,
they mistakenly labeled them as a Class 6. I haven't.
That would be a different argument at trial. I'm saying the way it's charged.
Make a correct record, right? You got to make it.
So, Mr. Myers.
It has to be true that.
As it's charged, and as it's charged as a 5.
Oh, so, I see what you're saying. I think your mic went out. Your mic went out.
4 to 43 years because of the stacking, okay? Worst case, all right? The plea agreement and probation is not available. Even if the judge wanted to give you probation, doesn't matter. The judge doesn't have a choice as charged, okay? If with the plea agreement, probation is available, available, so that's the first big difference. This probation is not available at charge, it is available under the plea. Under the as charged, we face between 4 to 43. Under the agreement, we face between 6 months to 2.5 on one, and a third of a year to 2 years on the other. So worst case scenario, running them consecutive, you face between 6 months to 4.5. Something big over here.
Okay. You know what I'm saying?
So I just want to clarify that.
Sure.
So I just want to clarify that
plea bargain is more
the
than the
maximum and the plea bargain is more than the minimum on the thing you just calculated.
Correct. So the maximum under the plea agreement, which would mean that the judge had to aggravate it, would be 2.5 years on the class 5 with the consecutive 2 years. So this is what under the law judges have to do. You start at the presumptive. So on the class 5, the lowest is 6 months, the presumptive is 1.5 years, and the highest is 2.5. When a judge looks, and if you look at the statutes under sentencing law, a judge has to give mitigating factors to go down from the presumptive and aggravating factors to go up. So you're right. Under the plea agreement, the 2.5 to 4 years is 4.5 years is more than the minimum you could face if you went to trial. But to get to that 4 at trial, if you were convicted of everything, the judge would have to substantially mitigate all of those charges, which is unusual in a case where you have 2 different cases to run both of them all concurrent and together. It's just unusual.
Right?
Yeah, I just want to make sure you understand, because that's what's important.
Even if I agree or not, you said you rejected the plea.
I will reject the plea if you cannot give me a factual basis. If you want to go back and try again, I'm willing to listen. I just need to make sure that...
Delineation between my factual basis and you accepting it.
So I can only accept a plea if you knowingly, intelligently, and voluntarily enter it. I can only accept a plea for that. To knowingly, you've got to know what you face. You got to understand the conditions of the plea. You also have to give me a factual basis about it. I need to know you're pleading guilty to these charges. If you're willing to do that, I will take the plea. If you're not willing to do it, I cannot take the plea.
Can we use the statutory definition of knowingly under ARS 1059?
So, sir, I am not going to take this plea. I can't make it any more simple than this unless you agree to me that based upon your course and conduct, Ms. Walker was reasonable to fear for her safety or the safety of her family. If you can tell me that based on your course and conduct, that which would cause Ms. Walker to reasonably fear, I can take the plea on that count. I still haven't gotten to the other ones, but I need to know that it was reasonable based upon the way this is charged.
Reasonable for her to fear for her safety.
Or the safety of her family. It has or.
You're asking me for my subjective, you know what I mean?
I'm asking you to agree that the course and conduct you did would make it reasonable for her to fear for her safety or the safety of her family.
And Judge, I apologize.
That's okay.
I'm really not trying to muck this up, but I think what Lane's caught up on is what the court's asking, and probably the problem statutorily with this statute, is it requires the defendant to put himself in the place of the victim, and whether or not it's reasonable for her to fear for her safety or the safety of her family is up to her, right? I mean, anybody who actually has that fear feels it's reasonable. I mean, nobody's going to run around and say it's unreasonable.
She's certainly entitled to feel how she feels, but
right. And I understand what both of you are saying. I just think under the law, there's many times where we use reasonable. Is it reasonably that when you do X, Y, Z, this would happen? Is it reasonable that by putting out her address, her phone number, her information, and I understand, Mr. Myers, that they're on a separate public website, but by doing it with regard to the other statements that you made, is it reasonable to believe that that would then result in her having a fear for her safety or the safety of her family?
So are you already saying that
because the jury will have to determine that reasonably too. So
are you saying that you are you just skipping the intentionally or knowingly, or are you saying you find that?
So you have to knowingly engage in a course of conduct. I'm okay finding that because
you have to knowingly engage in conduct that would make her fear for her safety, not just engage in conduct.
Right. So, but what I'm trying to make it so you understand where I'm hung up.
Because I read the ARS, because, you know, this legal jargon is the technical nomenclature of the law. The law gives you the definition of knowingly, not Lane Myers or Shannon Walker or
so,
Rachel
sir,
Stiles.
I need to know that you agree that it was reasonable based on your knowing conduct of putting her address, phone number, information out there online, that you knowingly doing that conduct, and by calling her, would reasonably result in her fear for herself or for her family. If you can say that, we can move forward. If you can't, again, no problem. We will not go forward.
Judge, would the court accept that we acknowledge that she did fear for her safety and that of her family, and that her fear was reasonable, and that she believed her fear was reasonable? We have no argument about that. It's just that he can't put himself in her shoes to know what she thought reasonable was, but we'll agree that she did.
Your Honor, I pulled up the Raji just to see how it kind of breaks it down too. Is, you know, for...
That's a jury instruction, just so you know, Mr. Myers.
Yeah, the jury instruction.
We always call them Rajis. I just didn't know if you knew that. Sorry.
So so it says the crime of stalking requires proof that the defendant, 1, knowingly or intentionally engaged in a course of conduct that was directed toward another person.
And I'm okay. I feel like I've got that.
And then it says, and that conduct caused the victim to reasonably fear for, and then that's where we get to the safety.
Isn't that up to her to determine, though?
Okay, so do you agree with me that you engaged in a course of conduct that was directed at Ms. Walker, that being the phone call and the 4 videos?
The phone call only.
Well, why do you put videos up? That was not directed towards her?
Absolutely not. Those are not directed at Shannon Walker. Yeah, I didn't tag
And
her
I don't
in
have
those.
a course of conduct. One phone call is not enough.
The directed at means that I would say, hey, Shannon, or I would tag her in social media, or is a K-Gun 9 story directed at the person in the video?
Absolutely. So I'm going to find that there's no factual basis for the plea agreement. I'm going to find that the court has gone through the Donald record and that Mr. Myers is knowingly, intelligently, involuntarily rejecting the plea because he's unable to provide a factual basis. I'm going to affirm the next court date, which I believe is just the trial. Just wanted to make sure. Oh, wait, there's a status conference, right, on July 14th at 9, it's 9 o'clock.
Are you also allowed to make orders in this case? To order them, because they've been telling me that I was going to get the pretrial witnesses for 2 months. The judge ordered them.
That's a separate order for Judge Metcalf. So no on that one. Okay. All right, but the parties should be prepared to proceed to trial. Thank you, everybody. Thanks for everybody's patience. Mr. Resnick, do you want to go ahead and take that? Just because I don't want to.
Well, that's it. All right, I'm going to switch over to the...
Which one? That old lady with the white hair. Oh. She's a bootlicker?
Yeah,
oh, with the bootlicker channel.
Remember I told you she was...
What's going on? The other door, it says.
Yeah, I saw one that was talking saying all kinds of stuff, and she wasn't even making no sense. But like talking shit on us like we're idiots. judges right here? What's that? Where's the elevator? You recommend it? That's what we're doing? Situation change? Oh yeah. Oh, YouTube. 45 in life.
I'm hoping that they're gonna go watch the press conference that might be outside or whatever. I don't know. We'll see. This might be the end of the stream. Oh. He might be like in the elevator. Looks like a temporary lapse in the Wi-Fi. Alright, let me close this window. Oh, I hear audio
Mr.
coming
Myers
back.
is knowingly, intelligently, and voluntarily rejecting the plea because he's unable to provide a factual basis. We're going to affirm the next court date, which I believe is just the trial. Just wanted to make sure. Oh wait, there's a status conference, right, on.
Uh-oh. Okay. Well, that's it for me. Oh, hey, kitty cat, stop. Alright, thanks for watching. Thanks for hanging out. I'll be covering the next hearing, which is a status conference, which is due like 2 weeks before the actual trial date. Yeah. Leave a comment, like and subscribe.